Hello, hello, hello. Happy Thursday, everybody. Woo, I'm moving the camera again on myself. Anyways, I have adjusted sound again, so let me know if you guys can hear me well enough. Or if I'm too loud, we're working on getting the sound figured out. Today, I've got a couple of good cases that they may have been seen on other channels. I don't know. I spend so much time watching court videos that at the end of the day, I don't want to watch anything else. I don't want to watch any more court channels. I don't want to watch more court stuff. So, they might have been seen on other channels. I don't know. But we've got, actually, the first part of the one video I did cover last week. But it's so good that I have to show it again. Because it's that good. It's a great clip. Anyways, let's get started with that first one. And you'll have to let me know how my sound is over top of the video. We're working on that. Also, I got some new backgrounds. So, I like this one. These are my photos that I've taken locally, so. Oh, and I got my mouse to...
Court does call the case of Hamilton Crossing versus Jeffrey Williams.
Jillian Engen for plaintiff.
I'm here, Shirley Williams.
Okay, hello.
Hello.
More importantly, who's the little one?
Winter.
Say again?
Winter.
Okay. It's a cutie.
Yes, I know.
Yeah, see. That's who I'm going to talk to. I'm not talking to anybody else. All right. Let's see. They were going to put, I think, 250 into escrow. I don't have that.
I did it yesterday.
At the court?
Yeah. I have the receipt.
You see it? Hang on one moment. We'll be able to take a look.
I see $250.
Yep, we see it. Okay. It just didn't get on my printout. And
Judge Simpson loves
you don't meet with Hawk until Monday.
I already met with Taylor, and she said that she's just waiting for the approval of it.
Oh, okay. All right. Real good. You're ahead of where I am then. Okay. Then let's do this. Let me adjourn it out a week and let's see. Uh-oh, another one. Hello.
Judge Simpson is
What's your name?
at heart.
Stormy.
Stormy. I like that name. That's the name I want. Stormy Simpson. See, that would have
It's
worked.
got a ring to it.
Yeah, I know. Maybe I'll change my name. I can do that legally. Anyway. April.
Can you sign off on it?
Yeah. April 28th, 2023 at 1 p.m., ma'am.
Okay.
And then we'll hopefully have some additional news and everything. Okay?
Thank you.
Thank you. You two little guys take care.
You say bye?
Bye-bye. Bye, Stormy. Bye. All right. See, that made my day. I'm good now.
See, he started off good.
Okay.
Started off good.
Okay. Yeah.
And then,
This gentleman
this is
assaulted
the
this
Ramadan.
morning. He did show up afterwards and indicated that because of prayer, he couldn't sign in until when he did. He's no longer present though, but he did show up.
Oh, okay. He's Muslim. That's why. Yes.
See, I included these two clips just to show you how Judge Simpson normally is. On a typical day, he's having a good day, everything's going great, and then in a minute or two, we get this next case. And
Yeah. Okay. Miss Engen,
Yes.
on the Hyundai matter, he did show up. He explained to my staff he is Muslim and because of prayer could not be here at the time that he was here or the time that we had it set. He did appear. I understand the nature of the case, but what I'm going to do is, given those circumstances, I'm not going to enter the judgment. I'm going to adjourn it out 1 week.
Okay.
That may be over your objection, but that's fine.
Definitely.
That's what I'm going to do that because
Okay.
What he indicates is the timing of the prayer and the ending and the breaking of the fast. I understand why he could not be here, presuming that he is Muslim, but all right.
Okay. Okay. Okay.
And so I'll set it for April 28th, 2023 at 1 p.m. Okay.
Okay. Okay.
Okay.
I'm gonna have to explain it to someone, but that's okay.
Well, either that or give them cultural diversity, and then they'll understand.
I know. It's just this specific one. It's fine.
Yes, I know.
The special.
All righty.
Thank you.
Thank you. And I will give me a couple of minutes. Judge Stormy needs a brief recess, and then we'll come back and we'll start our 10 o'clock block, Mr. Pantera. All right, court's in recess.
All rise. The 14A District Court for County of Washington, State of Michigan is now in session. All those applicants for the court are near.
Look, guys, this gets rough.
You may be seated. Court does call the case of Meta versus Jackson. Mr. Meta, actually, you're on this side, Mr. Jackson. All right. The landlord-tenant matter. And Mr. Meta, how much is it you claim he owes?
Claim now the present claim is $3,025.
$3,025?
Yes.
Jackson, how much do you think you owe?
4 months.
4 months?
Yeah.
Which, how much is that per month?
600.
600 a month? So you think you owe 2,400? Okay. So there's basically a $625 difference between the two of you?
$5 per month is just for 5 months. From December to this month.
I don't math, but his math ends up working.
He wants to show me something. What is that?
Ledger you said. Ledger for the-
Let's show it to Mr. Jackson.
I remember seeing this paper before.
Pardon? Right. I don't even know what it is because I haven't seen it myself. So let me look at it. Yeah. And then we'll talk about it. So is your rent 605 or 600?
605.
605.
Is it?
Yeah.
Okay. Okay. All right. So hold on. When did you move in? Was it the 15th of or halfway through October?
I think is either November around that time.
Okay. Okay, so Mr. Jackson, let me ask you this. I mean, it really won't matter. You must have moved in October only because He's got the security deposit on it and said they received 300. So that sounds to me like it was mid-October or somewhere around there. All right. So November of 2022, you paid $605. Okay. Did you make a payment in December?
No, I didn't make a payment in December, but
Okay.
like I said, the agreement was really well, in my opinion, why I think we're here, because first he used to like talk to my mom, like I used to be like girlfriend, boyfriend, and then until they stopped talking, and that's when everything went left. We had an agreement about everything, but until they stopped talking, that's when everything just went left, really.
Romance went south.
No, you telling me that story, it went left. So your mom and Mr. Mehta?
Yeah.
Okay, so what did you think the agreement was?
He was trying to wrap his head.
Well, I guess this other relationship was going on.
Well, the agreement was when I talked to him, well, he knew that I had to come here. I didn't, have a job. I had to find a job and everything. And we talked about when my taxes came, that was when I was supposed to pay them. But then I had to amend my taxes, so that took the process even longer. So that's how we're here.
Okay, so you say when you came here, where'd you go?
Kalamazoo.
Okay. Is there a lease at all?
Yes, the lease I gave you. Want it?
Yeah. We'll show that to Mr. Jackson, make sure it's. Was that
He has the copy. He signed it.
Yeah, this is the one.
That's the lease? Okay.
Okay, that was the nurse from my doctor's office, and she, every time I'm live streaming, she calls with some sort of a question. I swear she calls every time I live stream. And I turn my phone to do not disturb and it's still running through. I'm not happy right now. Sorry, that's what that was about.
So, Mr. Jackson, there wasn't a payment. I mean, is it correct you didn't make a payment in December, January, February, March, April?
Yeah.
Okay, all right. So what I come up with, well, you tell me you owe 24. If I count 5 months out, I get 30.25 that you owe. Because I have 5 months. I have December, January, February, March, April. That makes sense to you?
Yes, sir.
All right. So, Mr. Mehta, if this is a non-payment issue, why did you file a termination notice?
I wanted no payment. I wanted him to go from here. I know somehow he will not pay, though he is working. He has a job. He has a good job. I have a proof of it.
I didn't ask all that.
He sounds like a dad.
I asked, if you don't want the money, you want him just to leave.
I want him to leave.
What's the term of this lease?
He was to be here for about a year.
So if that's the basis for the lease, a year, then how are you terminating his tenancy?
But he doesn't want to pay. If he would have paid, I would have agreed. If he would have paid, I would have agreed to continue with him.
Okay, well, that's the part of the problem, because I have the wrong forms. You filed the wrong type of case. Because you gave him a notice to terminate his lease, but he still has a lease. He has the ability to redeem the property. Who are you?
I'm his son-in-law. I stay with him in Kalamazoo. I'm in Kalamazoo now. I'm not here.
Okay, you keep raising your hand. What do you want to tell me?
He has been making false promises since December. I will pay, and then he don't, and then he come up with another excuse. And he has been,
Okay, I'm just saying this. Let's assume everything you say is true. Okay? You filed the wrong type of case.
I filed for his eviction. I don't want money from him. Let him go.
But you just said if he paid, he could stay.
He could have paid, but he didn't pay. If he would have paid, he would have up-to-date payment.
It doesn't work that way. It doesn't work that way.
Let him pay them.
Your Honor, he will not pay. He's just.
Okay, you guys can keep trying to shove that round peg into the square hole. I'm just telling you, you filed a termination case. You're telling me that if he had paid, he could stay. Right?
I could have been good for him if he would.
Okay. The problem is, in this type of case, he doesn't have that option.
My option is no money. Let him go for it.
Yeah, it doesn't work that way.
Tell me now, I am a senior citizen, 83 now, 83, and I'm making only $400 Social Security. And I was depending mainly on the rent, which is not coming.
Okay. I feel bad for you. The problem is, you got to do things the right way.
That's how things work. You got to do them the right way. Follow the rules. It's not that hard.
So why did it take you so long to get to the court if you wanted him out? Because according to you, he hasn't paid rent since December.
Yes.
You don't file anything till March.
First time it was wrong. You said my notice was wrong. So I had to wait.
Yeah, it's wrong again. If what you're claiming, he's got a lease.
Yes.
On what grounds are you terminating the lease?
It's non-payment basically.
Then you have to file a non-payment case.
I don't want the payment from him. Let him get out from this place.
Oh my gosh.
I want my house back so that I might be able to sell it or maybe get somebody.
Mr. Mehta, you don't get to make the law. There are different types of cases you can file. You can file a 30-day claiming that he violated, that you're terminating his lease, but you have to have grounds for what you're doing that when he's got a 1-year lease. Or you can say it's non-payment. And if it's non-payment, then you're going to say what he owes. The judgment is going to indicate that he has a certain period in time at which to pay. That's not what you did. And it almost seems, I mean, why are you punishing him this way?
I'm being punished because I have no food now. I have only on Social Security of $400 I get. And some help from them. My daughter.
Can I say something?
Go ahead.
If he wants to pay, he can stay till the end of the lease. That's what we talked.
Okay. And that's what the problem here is. You can't say I'm terminating his lease because he hasn't paid. If you file a case that says you either have to pay or stay, then fine. But that's not what you filed.
So what did we file?
You filed a case that says you're terminating his lease.
On the ground of non-payment.
The lease doesn't give you can't do that. Not with this lease.
It is last 5 months, not a penny has been paid to me.
Okay, so
I did not get a penny from him.
So here's what's crazy about this. Had you done the right type of case, right? There are programs out there may have been able to pay the rent.
I would have allowed him. He would have paid to me. But I see that there is no indication from him. Though he's working.
Do you hear anything I say?
Hi, Terry Sue. Thanks for joining. I apparently was muted the whole time I was trying to talk because my brain is not engaged. You only need to go back about 10 minutes, maybe most, because the first 2 clips are of Judge Stormy Simpson. This was that day. This is how his day ended when we adopted Judge Stormy Simpson. This is his very last case, and it is a bit of a doozy, although you're not missing a whole lot at this point. The good part's coming up.
Say.
I can hear again. Please tell me. I'm 83 years old, man. I may not have heard.
But what did I just say? That if you had filed the right type of case, then you could get all this rent paid, get him over this hump, and then let him pay each month. Young man, you told me, why do you think you're here?
I really think it's because him and my mom.
I have a feeling it's a common.
When did they start going out talking? Or you want to put that?
I really don't know. I just came over my mom's house because I haven't talked to her in a while, and she was talking to him, and that was about around the time that the lease got signed. And then a couple months after that, he was leaving voicemail saying, "I can't talk to your mom. Can you contact your mom for me and call her?" And to this day, me and my mom relationship not even good because of him showing up to her house, and yeah, to this day, our relationship is not good.
All right. Let me ask you this. Do you want to stay?
Yeah.
Here's what we're going to do. I could hold a trial, dismiss this case because you don't have a right to necessarily terminate his tenancy. Or what I can do is I can hold my decision, and I'm going to elect to hold my decision and allow you to apply for assistance to get this rent paid.
Sir.
Okay? So, yeah, you have a, I couldn't get it out. I just couldn't. It's late on Friday. And I was going to call you something that I probably shouldn't.
I appreciate that.
I do. Thank you.
You want to call Cormus and
Can
wheeling
you
something
write
back?
down Hawk's number? Yeah, you have paper. All right. So here's what I'm going to ask you to do. I'm going to give you housing access for Washington County's number. Okay. Now you're in. Well, hold on. We may have a problem. It may not work for you. Is it just you in the place?
Well, me and my daughter.
How old's your daughter?
She's 2.
Oh,
Beautiful.
should have brought her to court. He would have loved it.
That may work for us.
The daughter is with the mom.
Yeah.
You know what?
His daughter is with the mom. His mom. It's not with him.
No, I have custody of my daughter. It's just my daughter goes to my mom's time to time.
Can I say something?
But I have papers to show that that's my daughter.
Just one thing. He he's lying in the court, and I can prove it. Number one, he is a caretaker from state of Michigan for his mom living here, and mom is 120 miles away. One thing.
Okay, so what do you want me to do with that?
He's not.
What do you want me to do with that?
He gets paid.
Help both of them.
He gets paid for that, for taking care of moms. Though he's not doing it, he's here only.
And your daughter is not there in the premises. That's another.
You know what I'm gonna do? I'm gonna dismiss this case. You're gonna have to start all over.
We can do that, Judge, but
Oh, I know you can do it.
he is not telling you the truth.
So what right now does that matter? You come here, you tell me that you want the money. And then if you have the money, he can stay. He says he wants to stay. So then I'm figuring out a way to do that. And then you guys, like, whatever, just make a U-turn, start heading in another direction and just want to badmouth.
Appreciate it.
So what do you want to do? Do you want the money or not?
If he pays money, he can continue to stay.
You know what? I didn't ask you for that long an answer. That's a yes or no. Do you want the money or not?
Yes.
You want to stay. Okay, this is easy. And man, I'm going to give you, because this is what I would do, just so that we're clear. If they had filed the case right, you would get a number, and I'm going to give you the number. It's 734-961.
Can we just admire how Judge Simpson handled that? Where, I mean, I don't know why my dogs are barking again. He's doing a phenomenal job, as always. I love Judge Simpson, that's no secret. But the way that we're still going to get, he's going to get the guy assistance, right? He's just making it a better situation all around. That way, someone's getting assistance either way. He's trying to help people out.
$19.99. Okay, we're going to give that to you on a piece of paper, and that's housing access for Washtenaw County. Now, this address happens to be an 08 address, and let me just find something here just to make sure I give you the right information. Yes.
Sir?
Lord mercy. Yes.
He got $3,700, he told me, for the tax refund, and he never paid anything to me. He said that I'm going to pay out of taxes.
What do you want me to do?
I mean, he wants to pay me taxes.
What do you want? You know what? You don't get to work this your way.
He only told me that he's going to pay me the taxes refund, which is he got it.
So sue him for his taxes.
I'm gonna let you get everything out you want. Go ahead. Tell me everything you want to tell me.
He told me that he's getting $3,700 tax refund, which he will give me. He'll give me all of it.
Good refund.
Now that he's not talking about that.
He's not talking about it.
You know what I'm gonna do? Here's what I'm gonna do. I'm not even gonna try to salvage the case. Because you'll be able to get the same thing if they do it right. So I'm just not even going to hear this. Filed the wrong type of case. This is not you didn't file a non-payment of rent case. Had you filed a non-payment of rent case, he has certain rights that he could assert at that point in time. Could also then have the right to redeem the property prior to being evicted from the property. The case you filed would not give him a right of redemption. I've tried to cut it down the middle so that both parties potentially could be happy. You don't want to do that. So I'm just dismissing the case. You can start over.
I'm asking
You
for
can
the-
start over. You could don't try it with me. I'm done.
Done means what?
I'm done.
What I'm-
I'm done.
what I'm-
I'm done. One more word, you're going. You understand that?
Woo!
So you will stay without payment. That's what.
Start one more word, and you're going to be found in contempt, and you're going to be spending the weekend as my guest. Case dismissed.
Woo! That's an angry Judge Simpson. That is an angry Judge Simpson. He is mad.
Yeah, young man, we're still going to give you that number to call them.
He is mad at that guy for not he didn't file the right case. He didn't. And then just I don't know, it's how he presented. It was very bad. Like, okay, you filed the wrong thing.
14A stands adjourned.
Not the end of the world. It is not the end of the world if you file the wrong thing, because you would ask to leave to refile properly, and then you would go for whatever, listen to the judge. But that guy was so intent on just talking and talking and talking, and he needed to zip his lips and open his ears and let his brain absorb what the judge was telling him, and he definitely didn't do that. And I have a feeling the case is going to end up back in front of Judge Simpson again anyways. Let's go to... This is a landlord tenant from... Wait, which one did I have? I have another landlord tenant. This is from the 14th. And they come back tomorrow. I thought they were back today for some reason, so I have it all set up to go. But let's... Let's watch this one real quick.
Am I speaking with Ashley Lowe?
Yes.
Good morning. This is Judge Middleton. I'm here at the courthouse, and you are remote. The file number here is 23284LT. Who you got with you there for moral support?
Mr. Widener.
I thought that was you.
Hey, Scott, you Nat.
Good morning, Scott.
Good morning.
This is a termination of tenancy matter. It's a foreclosure action. And as a defendant in a foreclosure action, you have the following legal rights. Attorney Mirella Albu has joined us here. Good morning.
Good morning, Your Honor.
We have a couple of foreclosure actions, and I was just going to advise these first defendants of their rights. Title of the case is Pennymac Loan Servicing versus Ashley M. Lowe and Occupants. You have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. If the action is for non-payment of rent, there's a different procedure that we follow, but this is a foreclosure action. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, you can contact the court and we can set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you would waive the rights listed above, but have the following additional rights. The judgment could not be enforced until 3 business days had passed. If you misunderstood what you consented to or what you were waiving, you could file a motion to set aside the judgment, and it would be set for a hearing before the judge. But if the judge did not find in your favor, the original judgment would stand. Yes, that's good.
I didn't record this and edit out all the pauses. I apologize. It's not
This
too
is
bad.
file 23284LT PennyMac Loan Services versus Ashley Lowe. Just advise Ms. Lowe of her rights as a tenant. This is a foreclosure action. There was a sheriff's sale way back in January of 2022, and the bank is asking to foreclose on this property. Ms. Lowe, what's your position?
Well, see, I thought I was in forbearance. That's why I'm confused by this. Because when I talked to PennyMac, and they sent me a letter last month or month before that stating that I was in forbearance. So I don't know.
Well, how long has it been since any payment has been made out here? 2 years or more?
No, I mean, I got my SSD about 1.5 years ago.
Well, the property has been sold at a sheriff's sale, and the foreclosure is
I get my SSD every month, and
in effect.
If I don't pay a bill, it's on
suspect
me,
no
not them.
payment has been made on this property in several years, and they served the notice.
No, that's not right. Because I gave them money when I got money. When money hit my bank account, I was on the phone with them.
All right. Well, when was that?
Well, around August of 21.
All right. So that's, yeah. Well, last payment is August of 21. That's coming up on 2 years. All right, Ms. Albu, what's your position?
Your Honor, I was looking at the account. We show that the due date is August of 2019. Yes, there was a foreclosure, redemption expired, and redemption was not made. So the plaintiff is seeking possession at this time.
Ms. Lowe, the sheriff's sale was in January, and you have time, 180 days to move to redeem the property, which you haven't done. According to them, no payments been made since August of 2019. You're gonna have to move out of there. It's been foreclosed on. No one's making the payment, and the bank wants the property back. The law requires that I adjourn this matter for at least 7 days for you to get some legal advice. Ms. Albu, I apologize. I'm going to be gone on a trip, and I'm not available until the 28th of April.
Yes, Your Honor, April 28th. That's fine. What time?
It's tomorrow, not today. I really thought it was today, guys.
Packed.
Oh.
8:30.
8:30. Yes.
Yes.
There's no way I know.
I can't promise I'll be awake at that time.
Will that work for you?
Yes, April 28th at 8:30, Your Honor, will work.
Record it. We can watch
Ms.
it
Lowe,
later.
does that work for you?
Yeah, that's fine.
All right, well, here's the circumstance. The bank has foreclosed on this property. No payment has been made in a long time. There was a sheriff's sale in January of 2022.
Huh.
You had 180 days from that day to redeem the property, which would have been June or July of 2022. Here we are in April of 2023, and they're asking to foreclose on the property. You keep shaking your head. This should not be a big surprise to you. There's a sheriff's sale. They posted it on your house.
I didn't know about that, but I was also, in and out of the hospital all year too.
Well, and no one's made a payment on the property in several years.
Yeah, that's not
So,
true. Like I have
well,
bank statements.
All right, well, you're real vague about it. I think I made it, well, at any rate, no pay, I'm willing to bet no payment has been made since January of 2022. Your house has already been sold at a sheriff's mortgage sale.
She don't even know about
And
that.
so my strong advice is
I highly doubt
you,
that there would have been a sign in the yard.
plan to move. Now I'm adjourning this 2 weeks rather than 1, because I'm gonna be gone. And then you're gonna get 10 days from April 28th to move out if they get what they're asking for. Which would be about May 8th, at which point you would be subject to being evicted by the sheriff. Now, you may have some defenses or legal explanation, but this is pretty straightforward. They followed all the steps for a foreclosure. In fact, they've given you way more time than they needed to. They could have pursued the foreclosure last July.
I would have.
And they've waited all the way until almost a whole year later. So you have the benefit of living there without making any payment. Ms. Albu, can you tell if the taxes are being paid or anything?
Your Honor, I'm assuming the bank has been paying them because they have to, so they don't go into foreclosure.
Yes. So you're not making the payment, you're not making the taxes. I'm sure you're probably paying the utilities, but this is a long process where the bank takes the property back. So we'll address this further at 8:30 by Zoom on April 28th. And if they get what they ask for, you would have 10 days from that day to move. Do you have any other questions?
What if she needs more than 10 days to move?
That's up to them. They can give her more. Otherwise, the sheriff comes and puts her stuff out in the street. People will always say, I need more time to move. It's been 2 years. I haven't moved yet. Yeah, this is a cold, hard reality check. No one's making the payment. The bank has followed the steps to foreclose on it. They've given you almost an additional year of grace time. And they want their house back.
Yeah,
the market
consider yourself very lucky.
is such they can probably sell it. So it's a tough thing. So this didn't sneak up and bite you in the ankle. This has been in the offing for several years. So you can get some legal advice, but my advice is you prepare to start being ready to move in early May. But I will see you on April 28th. Do you have any other questions?
No, sir.
All right, I'll see you then.
Okay, now we are going to move to Judge Simpson, and this actually happened today. Sorry, guys.
Court calls the case of the people versus Shubham Chatterjee.
Good afternoon, Your Honor. Grace Britton, appearing on behalf of the people.
And Your Honor, Joe Simon on behalf of Mr. Chatterjee. Mr. Chatterjee, will you please state your name for the record?
Shubham Chatterjee, Your Honor.
And what are we doing? Why is he? Okay, what are we doing?
The end of this one.
Your Honor, I've been informed by the people that there's pretty substantial continuing investigation, and therefore I'm requesting an adjournment of the probable cause conference. Before we set any date for that, however, I understand that people want to address bond, and that may adjust.
I figured they would. So, okay.
That's correct,
Go
Your
ahead.
Honor. Thank you. Your Honor, I have spoken with Mr. Simon at length and advised him that we have received supplemental reports in this case. We now have knowledge that there may be additional victims, text messages of the defendant threatening to extort the victim, break her bones, force her to be his sex slave, and kill her. We have also received evidence from their phones, and we have video evidence of the defendant sexually assaulting the victim, exerting his physical control over the victim to suffer cruel and extreme physical and mental anguish.
You guys hear that?
Those videos, Your Honor, appear to have been reported by the defendant, and they show conduct that are the basis of several additional CSEs that are likely going to be charged, including a torture charge. As a result, we are asking the court to remand the defendant under MCR 6.106B1B. The people did make this request at arraignment, but a bond was set of $250,000. It is my understanding that the defendant's family is wealthy and he was able to post that bond.
Did you guys hear that? He recorded himself raping these victims. And I think it sounded like they said that he published it or something, but he's been threatening to break their bones and like assault them again. What the hell? That's extremely disturbing. And the fact that he is out on bond and making these threats is not okay in my book as a resident of Michigan. I don't okay this. This is not okay.
Response.
Your Honor, I have a number of things to respond to. First, the people did not make this request at the time of the arraignment. I personally attended it. The people requested a $500,000 cash bond, and the magistrate set a $250,000 cash bond. That's my recollection anyway, and I'm pretty confident in it. The other thing is, Your Honor, the specific things that I have been made aware of, if they're going to amount to other charges, then bonds can be set accordingly if and when other charges arise. The statement with respect to other victims, from what I have been provided, I think was just very overstated. I understand there may be another matter that's being invested in the state of California, not here. And I am not aware that any victims have presented criminal allegations against my client here in the state of Michigan. And also my client maintains that he was not guilty of any other matters in addition to this one. Your Honor, I have some specific rebuttals that I don't want to, I think might be better stated the bench, because these are all very sensitive allegations and rebuttals. If the court wants me to detail them on the record, I will, but I just don't think that's appropriate here. And so I would make that request now, but if you want me to go into detail, I will on the record.
Initially, trying to see what the people's initial request was, but I don't see it on their law enforcement bond form.
I apologize, Your Honor. I can't confirm that it was 500,000 or a remand request. I was not the attorney at that time. However, I do have notes that they did ask for a remand, but I could be mistaken.
And Your Honor, I also, in addition to the sensitive things I referenced, I do have some other things to say. But if you want to just kind of pursue this one point, here's what I recall. And like I said, I attended that. I know that denial of bond was recommended. And I think there was excuse me, I said that wrong. It was referenced. I think that then the request was made, perhaps in the alternative, for a $500,000 cash bond. because I remember discussion with the magistrate that denial of bond for murder charges and denial for bond in capital cases that are not murder charges have different standards. And I reminded the way that we have capital charges in these three accounts is by use of a weapon. The weapon that's alleged here is a belt, and that's where the sensitive matters that I would like to address with the court, why I think we ended up with the bond that we ended up with. I want to say one other thing. The message, the threats that were just referenced by the people were also referenced at the time of arraignment.
I recorded that arraignment. They asked, the prosecutor did ask for bond to be denied. Amy Reiser was the prosecutor that day.
Okay. All right. My recorder was actually present there, and she is recalling that Miss Reiser did ask that bond be denied. And then ultimately it got to where it got to. Why don't you put counsel into a breakout with me, please?
Okay.
I'm going to take this opportunity to talk to you guys and remind you I'm reading a documentary. This documentary is about the dentist I had as a child who was convicted of 15 counts of sexual assault on a child under the age of 10, and child abuse. And 3 years later, his conviction was overturned due to a technicality as of improprieties in the prosecutor's office. He was then given a sweetheart of a deal to plead no contest to one count of child abuse and no further time served, removed from the sex offender registry. And he was done. And he is a free man walking in our society, walking around in our society. I am one of his hundreds, if not thousands, of survivors, and there is a long-lasting, deep impact of what this man has done. And I'm making a documentary about it because I've discovered that he's not the only one, and it's still going on today. And this is the same community that Larry Nassar preyed on, his own community. So the prosecutor ended up pleading guilty to human sex trafficking that same calendar year that he offered this sweetheart of a deal. So I'm going to put up my PayPal link. I'm not trying to hate begging, grifting, whatever, but I have to buy equipment. I need to get a microphone. I also have to get the money to pay my attorney to write contracts because you need contracts. And just to show like how legitimate this is, I have the survivor that he was convicted of sex offenses against. He's a part of this documentary. I have former staff, former parents of patients, and many patients. And I also have the lawmaker that put a law into action that handled the situation. Well, would handle the situation in the future. So I will throw that link up. And then if you want to put in the notes, or whatever, just say that it's for the documentary or equipment, whatever. That is what it's going to be used for. All of my money that or any revenue I get right now on YouTube is literally being turned right back into equipment and stuff for the channel, so that I can hopefully start bringing you guys better quality videos, I know my microphone is not the best, and apparently sometimes I come across as yelling, and I'm not. Don't mean to. Anyways, let's. I don't know. This is where I stopped, actually. So I don't know what he said when they came back.
Okay. They're both out. Okay. In the Chatterjee matter, record should reflect we've had a bench conference in this case regarding certain information and otherwise. The court is going to adjourn the probable cause conference. I'll adjourn that to May 11th, 2023. That will be at 3:30. That will be in person. We will also at that time be addressing specifically the bond as well as any conditions of bond.
Okay, you guys, I don't know what happened, but my page reloaded. That was really weird. Okay. So yeah, that will be May 11th, so I will have to watch for that. And then I've got one last video. I had edited it to post individually. I just never added any comments. Welcome back, friends. This is Michigan Crime Time, and I am your host, Jess. This is your first time here. Welcome. I am not an attorney. I am not making any legal conclusions, nor am I putting forth any legal advice. All comments are my opinion, despite any verbiage that I may use. All persons are innocent until proven guilty in a court of law. And last but not least, my videos are not the official court record. So to start with, today we have some cases that are examples of how you should talk and behave in the courtroom. Then we have some cases that are some examples of what not to do. So, as you guys know, my videos are often demonetized due to the nature of them. So, in the description are the links to join the membership for my channel if you'd like to further support me. There's also the link for the merch shop. I am working on my Judge Simpson themed merch right now, actually. So keep an eye out for that. Let's get to the courtroom and see exactly what I'm talking about.
Court does call the case, People versus Keyshawn Jorgensen.
Good morning, Your Honor. Regina Garrett-Kiraher on behalf of Mr. Jorgensen. Keyshawn, could you state your name?
Keyshawn Jorgensen.
Your Honor, today is a date and time set for sentencing. I have received the PSIR as well as the Von Schwartz report and reviewed them with my client. And at the appropriate time, I would just like to allocute for a moment.
Okay. Are there any material deletions, corrections, or additions to those reports?
No, Your Honor.
All right. Very good. What would you like to tell the court before I impose sentence?
So Mr. Jorgensen presents himself to the court after having actually had this case going on for over 2 years. He was on tether while he was on bond and did not have any type of violations. He also has been off tether now and hasn't had any violations as far as drinking alcohol goes. He is working now. He actually has 2 jobs. It was a little complicated to understand, but he does work at two different terminals at the airport. And Your Honor, he recently started those jobs, and because of the structuring of them and the way that the terminals, the way that his work schedule works, he winds up only being off 1 day per week. So we would be asking the court to think about allowing him to either serve, and I'm not sure if the jail can accommodate this, but to serve the additional 4 days as 1 day at a time, and or to suspend those days along with the remaining sentence until the end of his probation. I have every thought that he really will do very well on probation. He's basically gotten off of alcohol all on his own. Even when we had him reviewed for sobriety court, they said by the time we got him assessed for it, he had already, I don't want to say resolved his problem because alcoholism is a lifelong issue. However, he had already done so well that they felt that they couldn't help him any further. So we would be asking the court, if at all possible, to minimize the fines and costs and then help him keep his job as far as the days in jail he needs to serve going forward.
How long would it take him to schedule time off?
Mr. Jorgensen, how far ahead in advance do you have to?
Really, I just need, I don't know, I don't, whatever, however much time y'all give me, I would just make it work. Like I said, I'm almost to my 90 days at one of my jobs, and I'm almost, like, I want to say a month away from 90 days at the other job. So it's really, however you guys want to do it, I'll do it. Like, I just want this over. Like, you know what I mean? I'm just, you know, on a different leaf in my life. Like, I quit the job at the bar, just even though like I had been there still 2 years while I was on tether and still, you know, able to still work there. And like, I'm ready for a change. Like, I'm just ready for this stuff to be over. So really, I don't know.
So would it help if after the 90 days, then you serve?
See, it really does sound like this guy made a change. He was on tether for 2 years, working at a bar as an alcoholic. It's actually, and staying sober the whole time. That is honestly amazing. I'm super impressed. This guy is like, he really knows he's got.
That would be perfect.
Well, I'm not going out that far.
No,
I didn't. That wasn't the question I asked.
I understand, Your Honor. He only has, I think, a month to go to complete his 90 days at his last.
I heard him.
Okay.
All right, Mr. Jorgensen, anything you want to say?
I just want to say I thank you guys, because, you know, I was going through a lot, and I was using I don't know, like I was just drinking like to deal with my issues. And like, since I've been in this courtroom, like I done lost umpteen amount of people while dealing with this case. And I didn't go back into, you know, the alcohol and just drinking and like getting rid of my problems. Like, it changed, like me being in.
See, drinking doesn't get rid of your problems, because they're still going to be there when you sober up. So really, drinking doesn't help you. It's a temporary escape, but long term, it does nothing for you. If anything, it actually makes them a lot worse.
This court, me dealing with these court cases and me dealing with these court dates, and actually you guys being on my neck, it helped me out a lot. It helped me out tremendously, because where I'm at in life is a whole lot better than I was 2 years ago when I first came into your courtroom. I just want to say thank you guys, and I appreciate like anything you guys have done for me, because it helped me out a lot. Like, without you guys, I don't think I would be here right now. And to really put it in fathom, like if it weren't for you guys, I probably would be in jail for a whole lot longer. So at the end of the day, like, I just thank you guys for, you know, doing what you guys have done and helping me, and seeing that I've been trying to change, and seeing that I've been working on myself, as well as, you know, taking the time out and actually caring. Because I see a lot of people come in this courtroom, and I see a lot of people come in here, but you guys actually care, and I appreciate that.
Jorgensen, I never know how my day's going to start out, but I appreciate all those words that you said. I think that certainly for my staff and the people around here, we care a great deal. And sometimes people understand that. Sometimes they don't, but all right. The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence, particularly the alcohol screening and assessment that identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court. You are placed on probation for a period of 24 months. You are to pay $1,255 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery cost, and $720 probation oversight fees. When can you get that paid, sir?
I can start on it now. I think I'm still in the hole with I think I'm still in the hole for the tether about like 2,000 or maybe 3,000, something like that. But I mean, I can start as soon as I get paid on Friday. I can start making payments on Friday as well.
Okay, how much can you pay on Friday?
We could start off with maybe, well, I want to say like $300.
Okay, so that's the 14th, is that right? Yeah.
Yes.
So I'll indicate $300 on the 14th. And then a payment plan as arranged by probation. All right. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the CCOP program or comparable program. You're to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I will order 365 days in jail, credit 1 day served. You're to serve an additional 4 days, and then the balance will be suspended. You're to report to the Washtenaw County Jail by 6 p.m. on April 28, 2023. Thank you.
Thank you.
Thank you, Your Honor. Thank you, Mr. Jorgensen. Have a great day, everyone.
Court calls the case, People versus Thomas Nichols.
Ready, Your Honor. Attorney Michael Kelly, P77187, on behalf of Mr. Nichols. Mr. Nichols, can you state your name for the record?
Thomas Nichols.
Good morning, Your Honor. Today's date and time set for sentencing in this matter. I have had the opportunity to review the pre-sentence report and go over same with my client. It's factually accurate. We have no additions, corrections, or deletions to make to the report. I'd just like to proceed with allocution.
Go ahead, sir.
Mr. Nichols is 33 years old. He's before the court with a second drinking and driving offense that occurred back on September 2nd of 2022. There was a blood draw in this case of 0.157. Obviously, looking back, Mr. Nichols understands the severity of the situation, and he is certainly grateful the situation wasn't worse with this being his second offense, drinking and driving. I first met Mr. Nichols at my office back on September 6th, about 4 days after this incident occurred. And if the court recalls, prior to his arraignment, I had voluntarily recommended that Mr. Nichols begin testing on the SoberLink device, which he began on September 15th of 2022. When we were at the arraignment on January 3rd of 2023, the supervision was transferred over to community corrections. Even though he had already been 110 days of testing, he continued to test 3 times daily through the conditions of his bond. And to date, Your Honor, as the bond compliance form includes, he has had not one violation whatsoever. So these are the positives to buttress against the negatives, that Mr. Nichols got the message early. 4 days after the incident occurred, he's in my office coming up with a plan, demonstrating his ability to follow through with his sobriety, to demonstrate a tangible way to show that through the testing that he's been doing. Meanwhile, he's had to juggle a lot. He's married 4 years. He has a 3-year-old daughter, has a baby on the way. He still works full time. And when going through this case, we did try to have him screened for sobriety court in Genesee County. He's a resident of Linden, Michigan. And that assessment was completed back on February 1st of 2023. And at that time, he was deemed not eligible because he was not a high enough risk and a high enough needs participant. And it was the recommendation of the 67th District Court that he'd be more appropriate for traditional probation. We contemplated whether he would move to Washington County to become eligible for this court's sobriety court, but with his young family and having recently purchased a home in the last year and a half, it just wasn't practical for him to uproot his family, uproot his child's schooling, and move to Washington County. It was never for lack of desire or, through his efforts, Your Honor. It just wasn't an appropriate fit. So he did have to accept the consequence from this. His license has already been revoked. He's had to figure out transportation for work, how to balance family commitments at home with his wife now having to do all of the transportation, including the transportation for him getting to work. But he's continued to work proactively through this case. He did complete the MAD panel on March 14th. And as I said, he's had zero issues with this bond conditions, which you hung a big one over him, Judge, too, a $15,000 personal bond. If he slipped up, he could have been in a whole world of hurt with you. And certainly you could have sent him to jail at any time throughout the pendency of this case. He has reviewed the recommendation with me, and he understands there obviously has to be consequences to his actions. But I'd ask the court to consider adjusting the time of his probation from 24 months. I think something more like 18 would be appropriate. As stated, he was on the sober link from September of 2022. From his bond arraignment on January of 2023, no issues, Your Honor. Certainly when I look at a drunk driving offender or a client, I can certainly understand when there's a recommendation for jail if the client starts trending in the wrong direction, if there were bond violations, if he wasn't getting things together, if he showed a naive attitude or was disingenuous about the severity of the situation. Those are not the circumstances here. So I don't really understand the rationale behind a graduated sentence of upfront jail, but my client understands that that is still within the purview of the court, and the court could certainly sentence him to a range of options. I just leave it up to your discretion, Judge. I understand there has to be a carrot and a stick in this case, whether it's 18 months, 24 months, that jail time's hanging over his head. As long as he continues doing the right things, he doesn't have to worry about that. But because he's already been doing the right things, I think this court should acknowledge that. This is the right way to respond to a negative situation. So with that said, Your Honor, I'll leave the probation and the jail time to your discretion. Have my client say a few words on his behalf. I know he's prepared a statement, and then we'll leave it up to the court in terms of sentencing. Thank you.
Sure, go ahead.
Yes, Your Honor. I, Thomas Nichols, hold myself accountable for the events that transpired on September 2nd, 2022, which resulted in my arrest and disciplinary action. I was arrested while under the influence of alcohol and recognized how serious of an infraction this truly was. The subsequent life changes and the time to honestly reflect has given me the opportunity to realize how poor of a choice this was. Since this incident, I've been on the SoberLink device with completely negative results since September 15th, 2022. I have been diligent and honest in my sobriety, and I am thankful for this. I look forward to not just following, but exceeding the expectations the court places upon me. I value the chance to improve my life for myself, my wife, my son, and my baby that is on the way. Building a stable future for everyone I value is incredibly important to me, and I plan to view this challenge as a chance to prove myself in ways that I may not have before. Through sobriety, I have taken personal inventory and come to the conclusion that alcohol is no longer a part of my life. More than just words, these paradigm shifts will be evidenced by my actions and steadfastness in following the mandates of this court. Thank you.
Thank you. The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient substance abuse treatment, attendance at AA meetings, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. It is therefore the sentence of the court. I'm going to place you on probation for a period of 24 months. You're to pay $1,255 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery cost, $720 probation oversight fees. When can that be paid?
Today.
Thank you. Pay that today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete an IOP program, including all aftercare recommendations with status reports to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation that has been completed. You're to continue the sober link until you're properly enrolled in an IOP. Pursuant to this statute, I will order 365 days in jail. I'll give you credit for the one you served. You are to serve an additional 4 days and the balance will be suspended. I'll order that you report to the Washington County Jail by 6 p.m. this Friday, April 14th, 2026, or a bench warrant will issue with no bond. Court calls the case, People versus Sarah Ostrowski.
Okay, so those two were outstanding examples of how you would do an allocution and with a paid attorney, so you know that costs them money. This next case, this is how you do it with the public defender, which honestly shouldn't be that much of a difference between a privately paid attorney and a public defender, but yeah.
Good morning, Your Honor. David Shannon, on behalf of Sarah Ostrowski. As you can see, Sarah's in the hospital with pneumonia.
Oh, no, no.
Oh, I'm sorry. Okay.
But we're ready to proceed. We reviewed the PSI. It's factually correct. There are no additions, deletions, or corrections. I don't think I've ever had any dispute with anything Teresa has ever recommended, and we'd ask the court adopt Teresa's recommendations.
You see how Shan tried to butter us up? You see that? You see that? He starts out, he's like, oh, everything's just fine. Okay, whatever. Anyway.
She is always right, Your Honor, so it may be a lesson for all of us.
Oh.
Was he including me in that? Oh, okay. All right. I don't know what Shan's talking about. Ms. Ostrowski, anything you want to tell the court?
I just want to apologize for my actions on that day. You know, I take full responsibility, and it was a really bad mistake that I made, and I want to say that it won't happen again.
All right. Well, I hope that you're doing better and that you'll feel better. That's, I think, the most important thing, even other than this. It is the sentence of the court. I'll place you on 4 months prosecutor deferred sentence. You're to pay $555 fines and court costs, $120 probation oversight fees. When can you pay that?
Today.
Okay, thank you. Pay that today. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service with proof to probation. There is no going to any Walmart store in the state of Michigan. You are to submit fingerprints with proof to probation. I'll set a review hearing that's to be held August 9th, 2023, 9 a.m. I will order 365 days in jail. That is suspended. All right. Thank you.
Thank you, Your Honor.
You're welcome. Get well, please.
Thanks, Teresa.
Thank you for the kind
See,
words.
why does Shan do that? Shan, I just pronounced the sentence, right? I just did everything, and he thanked Teresa. I know she is. I mean, I get it, but not really. Yeah, that's fine. Shan needs to understand. Judges have feelings too, but that's okay. Anyway, thank you, David.
All judges matter.
Court does call the case. The people of Pittsfield Township versus Aaron Brown.
Okay, this is
Reed, public defender, with on behalf of Mr. Brown. Mr. Brown, could you please unmute and state your name for the record?
Yeah, this is
Aaron Brown.
Thank you.
Outstanding. That's
Your
all
Honor,
I-
we have reviewed probation's recommendation. It is for jail time, and so obviously this is not something that Mr. Brown is looking forward to, but he does understand that is most certainly what the court will order. We would just like to ask, if possible, for him to be allowed to turn himself in on Friday, as he has a bit of time to serve in custody and would like to be able to get his affairs in order.
But he knew that was coming up.
Is there anything you want to say?
Should have been taking care of his affairs.
I got prom next month. I've been here 17 years.
Prom.
I'll turn myself in after that. I'm not coming there Friday. I ain't missed a beat with my daughter. I've been here the whole 17 years. I can't turn myself in Friday.
Congratulations. You want a cookie?
I don't want to go against your orders. I wish it could be another way. I'm not running from you. I had this thing on when I come to you. I'll turn myself in, but it will not be Friday.
Well, tell you what, you can elect to do it your way, or you can elect to do it my way. That's going to be your choice. You decide you don't want to do an alcohol screening and assessment. You don't want to do anything. You continue to violate on the scram tether. So here's what we're going to do. It's a sentence of the court. I'll just order the $125 statutory fees. I will order 93 days in the, hold on a second. Is that the max on this? Yeah. I'll order 93 days. Well, hold on a second. What did he plead to? Operating one. Okay. I'll order 93 days, Washtenaw County Jail, credit to defendant to serve the balance. Defendant has told me he doesn't want to report, so we're going to do it this way.
I didn't tell
You
you.
report. I'm going to order that you don't get to choose your time.
I mean, can we work?
I'm going to order that you report to the Washtenaw County Jail by 6 p.m. today. Failure to report there'll be a bench warrant issued for your arrest. That event bench warrant will issue with no bond. So you don't report 6 p.m. today, your choice. I'll send people to get you. It's real easy for me. Thank you.
That's sure.
You know he will too. You know Judge Simpson will send people to get him.
Court calls the case. People versus Rishi Cavallero.
Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Cavallero. Mr. Cavallero, could you please unmute and state your name for the record?
Ricky Cavallero.
Thank you.
All right.
Your Honor, we have reviewed the recommendation in this matter. We have no additions, deletions, or corrections, and we would just ask that probation's recommendation be adopted.
Really? Does he want to make his own sentence too?
No.
No, I'm kidding. I'm just kidding. I'm kidding.
More than willing to
allow me.
I'll be cooperative, but if people want to make up their own thing, that's fine too. Mr. Cavallero, anything you want to say, sir?
Well, I'd just like to apologize to the owner of McDonald's. That was actually an accident, and I didn't even know I broke that. And from my time being here, I just like to say watching you was an honor, funny, and your wit. And I think you should have your own TV show like Judge Judy.
I agree.
You're hilarious. You really are.
I agree.
I guess, thank you for that.
You're hilarious. That's like watching TV. It's amazing.
See, Judge Simpson's on.
Have fun here when we can.
I don't think I asked him. What part of Pennsylvania you live in?
Oh, here we go.
What, east of Pittsburgh?
Oh, that's right. Because you're a Steeler fan, right?
Yep.
Okay. All right. Then you're good with me. All right.
When they're winning, I'm a fair weather fan. So.
Oh, okay. All right. That's okay. Take them as they come.
All right.
It's a sentence of the court. I will place you on 4 months prosecutor deferred sentence. Order $555 fines and court costs, $120 probation oversight fees, $50 restitution to McDonald's payable through the court. When can you pay all of that, sir?
I need some kind of payment plan. I'm on disability, and I got like 2 months left. I had an accident a couple of years ago where I broke 4 ribs out of state, and I'm paying that hospital bill still. But that should be
All
done
right.
in 2 months. I mean, I could pay the whatever I have to pay right now, the $50 or something I have to pay.
Yeah. Here's what I want you. Here's what I want you to do. The $50 would need to be paid. You can get that paid, say today. Well, you got to get it in cash here. So I'm going to say that $50 will be due by May 1st, and then the rest of it will set up you on a payment plan with probation. Okay.
So I send a money order or a check, or how does that work for the $50?
It's restitution, so that's going to be the issue.
Your Honor, I believe that it requires your permission for a money order for the restitution to be spelled out for the clerks in order for them to take that for the restitution.
Yeah, I know.
I mean, I could put cash in an envelope, and I don't know if it'll make it there.
No, let's not do that. Because then they get here, somebody say it didn't get here, and then now. All right. A money order is acceptable for restitution. All right, so get a money order, get it to us.
Okay.
Okay, for the 50, and then.
Made out to.
Pardon?
Who should that be made out to? I don't want to.
It should be made out to the 14A District Court.
14A District Court. Okay.
Yes, sir. And we'll take care of it from there, and then talk to Ms. Polera regarding the rest of the payments and how we set it up.
Okay. She'll
All
send me
right.
an email or something then to figure out all that.
Yeah, she'll work with you on that.
All right.
All right.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as directed by probation. You're to complete an anger management class as directed by probation. There's no going to McDonald's at the 3001 Lower Road in Ann Arbor, Michigan. There's to be no use of assaultive, threatening, or intimidating behavior. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. I will set a review hearing in this matter for October 11th. Is that right? That can't.
Your Honor, that's my error. It should be August 9th.
Thank you.
4 months.
I just thought my counting was off. August 9th, 2023 a.m. I'll order 93 days in jail. That is suspended. All right.
Thank you.
Thank you, sir.
Your Honor.
All right. Thank you for your kind words also. I do appreciate it.
I'll see you on TV.
Okay. Court calls the case People versus Joseph Curry.
Morning, Your Honors. Public Defender Cosimo Basie on behalf of Joseph Curry. Mr. Curry, could you state your full name?
Joseph Curry. This is a violation of probation hearing. Miss Polera. Where are you?
I'm sorry, Your Honor, who did we call?
I called Mr. Curry.
I don't believe he's mine.
Looks like it's a show cause hearing, Your Honor, is what I have.
Is it a show? You have it as a show cause?
That's what I have on my docket.
Uh-oh, they lost the record. Someone messed up.
When did you turn yourself in, sir?
22nd, but it was like to the 23rd because it was like around midnight.
He was a little late turning himself in. That's why he's before me. Because there was a bench warrant issued with no bond because he didn't report to the jail timely.
Yeah, I'm gonna apologize for that.
Well, now you do because you got caught.
No,
All right.
I did turn myself in. I didn't get caught. This is late. I'm sorry.
All right. So what I'm going to do is defendant to serve remainder of the 93 days imposed earlier.
Is there any way
as well as he's to complete the Don Farm in Jail program. I may consider early release upon completion, but it's unlikely. I'm just going to let you know because you didn't turn yourself in on time. And then he's no longer on probation, so he's discharged without improvement. Anything else?
I was just gonna ask the court if there's any way I can do weekends. I got a lot of family issues. My mom's in the hospital, just went to the hospital, and I need to get back to work because my family is struggling right now.
Sir, let me just tell you, I don't mind working with people, but I ordered you to jail on March 1st. Told you to report that day. Asked you to do the Don Farm in Jail program. If you had completed that program, which you might have it done by now, I certainly would have considered early release and likely would have. However, you made your decision that you were going to do it your way. And so I don't know if you turned yourself in or we caught up to you, whichever way it is, doesn't really matter. We didn't get a hold of you until some 20 some odd days later. You have attorneys, you didn't contact them regarding it.
So when he said a little late, like it was he turned himself in right around midnight and it was a little late. It's more like a whole lot of late.
Any difficulties you had or anything like that, you just wanted to do it your way. So we did it your way. Now we're going to do it my way. Really simple. Thank you.
All right.
Wait for him to say.
Close the case. People versus Tanya Phasing.
Silvana Reed, Assistant Public Defender, with and on behalf of Ms. Phasing, could you please unmute and state your name for the record, ma'am?
Tanya Phasing.
Thank you. And did you have a chance to review the report that was sent over? Ms. Phasing, did you have a chance to review the report?
Yes, ma'am. Yes, I did.
Okay. And do you have any corrections that need to be made?
No, absolutely not.
Thank you. Your Honor, we would just ask that probation's recommendation be adopted.
Ma'am, is there anything you want to tell the court before I impose sentence?
I just want to, thank everybody. Thank you, Judge Simpson. I'm 258 days sober.
Yay.
Yeah, thanks to you and, Teresa, everybody. Alcohol is not a way to treat anxiety, depression, anything like that. I lost my nephew 4 days ago to the same problem, and I'm proud that I've come out the other end of this thing and hope to remain that way. So thank you.
You will. All right. And the important thing is sometimes life always gets a bit difficult. Yeah. And we start trying to spiral and then we look out for those crutches. All right. But now you got another crutch because I think we all need them. I think I hate to put it that way, but you can always give us a call. Yeah. And just reach out to us. Okay.
I think
nothing is so. Pardon?
I said I think Teresa knows that.
Your Honor,
yes.
Ms. Phasing is on probation for another OWI that she got sentenced on a couple months prior, and she's been doing fantastic on probation.
And I'm glad to hear that. I'm always glad to hear that. All right. So you keep up the good work. Okay.
Thank you.
And congratulations on the 58 days.
Thank you.
It's a huge accomplishment. Sometimes it doesn't sound like much, but sometimes you just have to make sure you acknowledge it and understand that that's an incredible accomplishment.
Thank you
very
much.
And Your Honor, it was 158 days.
It's 158. That's even, my goodness.
It's more. 8 months.
Yeah, it's been almost 8 months, almost 9.
Okay. That's even better. I missed the one. Oh my goodness.
Yeah.
That's not easy.
That's fantastic.
That is not easy.
The court this is not a serious misdemeanor as defined in the statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment and continued attendance at AA meetings. The court will follow the recommendation of probation, which is stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance. with recommended treatment. In this case, therefore, it is a sentence of the court. You're to pay I'll order you 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. How can you get that paid, man?
Can I have a payment plan, please, Judge?
She's on one with the other matter. Is that correct, Ms. Blair?
She is, Your Honor.
All right. Then probation plan as directed by probation.
Thank you.
I will waive on this case the probation oversight fee, so there's not additional amount for you. Okay.
I appreciate that very much.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. Attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation, which has already been completed. I'll order 93 days in jail. Credit 1, the balance is suspended. All right. Thank you.
Thank you,
Keep up the good.
I appreciate you. Thank you.
Thank you. Okay, people versus Leisha Green Gifford.
Some public defender, Qasim Obesi, on behalf of Aisha Green Gifford. Do not see her here.
Uh-oh. Uh-oh. That's a problem.
You're having a good day, aren't you?
Oh, yes. Good day for me.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give a 10% privilege on that. That will issue immediately. Court calls the case. People versus Sherrod Stokes. We don't have a defendant here. Sherrod Stokes. Let me see. We have 410. All right. Bench warrant will issue for defendant's failure to appear. Again. Bond will be set in the amount of $5,000. 10% privilege. That warrant will issue immediately.
For the record, that was not one of my clients, Your Honor. Not this time.
Pardon?
I just wanted to say for the record, that was not my client.
Oh, that okay. So not only okay, we got it.
You had
It's
several
not my client that
clients
didn't
not
show.
show up
So,
earlier.
what did you think of those cases? That one guy telling Judge Simpson what his sentence was going to be?
No.
Definitely not the way to go about doing things. That's why you have an attorney. Anyways, Chimagwitch, thank you for watching, and we will see you next time. Oh, don't forget to like and subscribe and share my videos. I appreciate the support.
Oh my gosh. Oh.
And I will see you next time.
The bloopers.
As you guys know, as you guys know, so check out these cases. I don't even know anymore. Fuck. Does that even sound okay?
I was asking my husband. I asked my husband in the living room if that sounded okay.
You know, maybe one year I'll get it right. I'll get to where I think I'm good.
Well, yeah. When I record the intros and outros, it ends up taking me, I feel, about 10 minutes. And then I have to edit it down until it fits within a minute or so. So I am not a professional-ish. I'm professional-ish. How about that? Okay, you guys. So that is what I have for you today. I know, definitely, I'm going to jump on tomorrow. I'm going to say, let's go for 1:15. That seems to be my time. Today, I had to postpone it because someone needs to fire my personal assistant because she keeps scheduling doctor's appointments on days that she's supposed to be live streaming. Does anyone know where I can find someone to replace me? Because I don't. Anyways, we'll be back here tomorrow at 1:15, and we're gonna watch the continuation of that landlord-tenant case from Judge Middleton, where the house was sold in a sheriff's sale. I honestly am very interested to see how that turns out. I mean, she didn't know about the foreclosure and the sheriff's sale. So that'll be interesting. There was another landlord case in front of Judge Middleton that I caught, and I thought I had that queued up, and I didn't. And I want to follow that one because there's witness testimony, and I don't want to give it away, but it sounds pretty interesting / juicy. But with that said, you guys, Shima Glitch, thank you so much for watching and supporting me and my channel. I do appreciate it. I do read every comment. You guys, I think, know that. I respond to most of them. So I do appreciate all of the support. I'd say I'm not doing too bad for someone that never wanted a YouTube channel. Anyways, in the description is going to be the links if you want to join my membership. Join the circle of friends. I am slowly going through videos and getting bloopers of myself, and also some judge bloopers, and I'm making up some of those. That'll be like for members only. If I get enough members, I'll do a members only live stream, where essentially you can ask me anything. That will be fun. Also, yes, so I do believe the link for my PayPal is in the description as well. Any money that you decide you want to donate to me or give me, you can put a notation as to what the money is supposed to be used for, and that is what it will be used for. Currently, right now, I'm trying to raise funds for a documentary that I'm making, again, about my dentist I had as a child that ended up being a convicted sex offender and pled guilty to child abuse, or was found guilty of child abuse and torture. And the judge called him the worst sadist he'd ever seen. So I'm working on that documentary. I need equipment. I need to have some sort of a contract drawn up for people that are participating in the documentary. I know you need that. And then the other ginormous expense is the FOIA request from the county that is $603 for me to get all of the court documents. So that's what I'm raising the money for, to help defray those costs, because I don't have money. I'm on disability and I have a YouTube channel. Anyways, again, Chimagwitch, thank you for joining me. I am working on uploading another video right now that is completely unrelated to anything with LawTube, but I think I'm kind of funny, but it's uploading. It might finish uploading tomorrow. I don't know. My internet is wonderful. Again, Chimagwitch, I will see you guys tomorrow right here at 1:15 p.m. Eastern Standard Time to watch some Judge Middleton. You guys have a great evening.